If you've ever sat down to write your will, you've probably assumed it's the one document that controls everything you own. Your house, your bank accounts, your retirement savings, that life insurance policy you've paid into for 20 years. Surely it all just flows through your will when you're gone. Here's the uncomfortable truth. For a surprising number of your most valuable assets, your will has no power at all. None. You could write the most carefully worded will in the world, name your children as beneficiaries in black and white, and it still wouldn't matter, because those assets were never yours to give away through a will in the first place. They already have their own instructions, quietly attached to them the day you opened the account or signed the paperwork, and those instructions override your will every single time. This isn't a rare technicality that only applies to wealthy families with complicated finances. It happens in ordinary households, to ordinary people, all the time. A father lists his oldest son as beneficiary on a life insurance policy back in the 90s, remarries, updates his will years later to split everything evenly among his children, and never realizes the old policy paperwork is still sitting there, untouched, waiting to send the entire payout to just one son the moment he passes. Nobody did anything wrong on purpose. Nobody was trying to be unfair. The will simply never had a say in the matter. So today we're going to walk through 7 kinds of assets that should never go into your will, not because it's illegal to mention them, but because your will has no authority over them, and treating them as if it does can quietly unravel your entire estate plan. Before we get into it, a quick and important note. I'm not an attorney, and nothing in this video is personalized legal or financial advice. Estate laws vary from state to state, and the way these assets are handled can depend on your specific paperwork, your state's rules, and your family situation. Think of this as general education, a starting point for understanding how things typically work, so that when you sit down with a licensed estate planning attorney in your state, you already know the right questions to ask. That's really the goal here, not to replace professional guidance, but to make sure you walk into that conversation informed instead of guessing. Here's why this matters right now, today, whether you're 45 or 75. Estate planning mistakes don't announce themselves while you're alive. They surface later, usually at the worst possible moment, when your family is grieving and least equipped to untangle a paperwork problem. A mismatched beneficiary form can turn a peaceful transition into a legal dispute. It can accidentally disinherit a grandchild. It can hand a life insurance payout to an ex-spouse instead of your current family. The good news is that every single one of these problems is preventable, and preventing them doesn't require a law degree. It just requires knowing which assets live outside your will and making sure their paperwork actually says what you want it to say. By the end of this video, you'll understand exactly which 7 categories of assets bypass your will entirely, why that happens, and what actually controls where they go instead. You'll walk away with a clear mental checklist you can use this week to review your own accounts. And if this kind of practical, no-nonsense estate planning education is useful to you, consider subscribing. We publish new videos regularly on wills, trusts, probate, and protecting what you've built for the people you love. Let's start with the first category, and honestly, the one that trips up more families than almost any other: retirement accounts. Your 401k, your traditional or Roth IRA, your 403b if you worked in education or for a non-profit, none of these pass through your will. When you open these accounts, you filled out a beneficiary designation form, whether you remember doing it or not. That form is a contract between you and the financial institution holding your money, and it legally directs where those funds go the moment you pass away. Your will simply isn't part of that conversation. If your will says your retirement savings should be split 3 ways between your children, but the beneficiary form on file still names your college roommate from 30 years ago because you never got around to updating it, the roommate wins. The financial institution is legally obligated to follow the beneficiary form, not your will, and not your stated wishes anywhere else. This is precisely why it matters to periodically pull up your retirement accounts and actually look at who's listed. It takes 10 minutes, and it can prevent a genuinely heartbreaking outcome. Let me paint a picture of how this plays out in real life. Imagine a woman we'll call Linda, who opened her 401k in her 20s, back when she was single and living near her parents. At the time, she named her mother as the primary beneficiary, which made complete sense. Over the following decades, Linda got married, had 2 children, and built a life entirely different from the one she had when she filled out that form. She wrote a will in her 50s that clearly divided her estate between her husband and her kids. But she never once opened her 401k paperwork again. When Linda passed away unexpectedly, her retirement account, by then worth several $100,000, went entirely to her elderly mother, per the decades-old beneficiary form, while her husband and children received nothing from that account at all. Her will's instructions were completely irrelevant to that piece of her estate. This wasn't a failure of Linda's intentions, it was a failure of paperwork that nobody thought to revisit. The second category works almost identically: life insurance policies. Just like retirement accounts, life insurance operates on a beneficiary designation, not your will. When the policy was issued, you named a person or people to receive the death benefit, and that designation is what the insurance company follows, full stop. Your will can say anything it wants about how you'd like the money distributed, and the insurance company will still cut the check according to whatever's on file with them. This becomes especially important after a divorce or remarriage. It's disturbingly common for someone to remarry, build a new life with a new spouse, and completely forget that an old life insurance policy still lists their first spouse as the beneficiary. Some states have laws that automatically revoke an ex-spouse's beneficiary status upon divorce, but not all states do, and even in states that do, insurance companies sometimes still pay out to whoever's named on the most recent form, unless it's been formally corrected. The safest approach is never to assume. Check every policy directly with the insurer whenever your family situation changes. Now let's talk about the third category, which surprises a lot of people: property you own jointly with someone else, specifically property titled with what's called rights of survivorship. This commonly shows up with married couples who own their home together, or with a parent who added an adult child's name onto a bank account or a piece of real estate. When property is titled this way, ownership doesn't pass through your estate at all when you die. It automatically and immediately transfers to the surviving co-owner, outside of probate, outside of your will, the moment you pass. This can actually be a useful and intentional planning tool for married couples who want a smooth transition of the family home. But it becomes a problem when people add a child's name to an account for convenience, say to help pay bills, without realizing that doing so has just given that child automatic full ownership of whatever's left in that account when the parent dies, regardless of what the will says about splitting things equally among siblings. One sibling ends up with the account, and the others are left holding a will that promised them a share that no longer exists. Our fourth category is closely related: payable-on-death and transfer-on-death designations, often abbreviated as POD and TOD. Many bank accounts, brokerage accounts, and even vehicle titles or real estate deeds in certain states allow you to name a beneficiary directly on the account or the title itself. It's a bit like a beneficiary form for your everyday bank account. The moment you pass away, that specific account or asset transfers directly to the named person, bypassing probate entirely and bypassing your will completely. These designations are popular precisely because they're simple and efficient, avoiding the time and cost of probate court. But that efficiency is exactly why it's so important to keep them updated and consistent with your overall wishes. If your will divides your estate one way, but a POD designation on your largest savings account sends that specific money somewhere else entirely, your family may end up with an outcome that looks nothing like what you intended when you wrote your will. Let's move to our fifth category: any asset that has already been placed into a living trust. If you've set up a revocable living trust and properly transferred ownership of a house, an investment account, or other property into that trust's name, that asset is no longer part of your personal estate in the eyes of the law. It belongs to the trust. The trust document, not your will, dictates what happens to it, and it typically passes to your beneficiaries without going through probate court at all, often much faster and more privately than assets controlled by a will. This is actually one of the main reasons people set up trusts in the first place. But here's the catch that trips people up constantly. Simply creating a trust document doesn't automatically move your assets into it. You have to formally retitle each asset, the deed to your house, the name on your bank account, into the trust's name. Many people create a beautiful, thorough trust and then never finish this step, meaning the assets they thought were protected inside the trust are actually still sitting in their personal name, exposed to probate anyway. Your will absolutely cannot override what's already correctly funded into a trust, and it shouldn't try to. The sixth category is one that catches business owners off guard. Business interests governed by a buy-sell agreement or a formal operating agreement. If you're a partner in a business, or you co-own a company with someone else, there's often a legal agreement already in place, separate entirely from your will, that dictates exactly what happens to your share of the business when you die. These agreements frequently require your business interest to be sold back to your surviving partners, or transferred according to a specific formula, rather than being freely passed on to your children or spouse through your will. It's not uncommon for a business owner to write a will, leaving their share of the company to a spouse who has never been involved in the business, only for that spouse to discover that a decades-old partnership agreement actually requires the interest to be bought out by the surviving partners instead. Your will simply doesn't have the authority to override a valid existing business contract. Our seventh and final category is real estate located in a different state than where you live and where your will is filed. This one is less obvious, but it matters more than people expect. If you own a vacation home, a rental property, or land in another state, and it's titled only in your personal name without a trust or a transfer-on-death deed, your family may have to open a second, entirely separate probate proceeding in that other state, a process called ancillary probate, in addition to the probate happening in your home state. Your will can still apply to the property, but the process becomes slower, more expensive, and more complicated, often requiring a local attorney in that second state. Many families are blindsided by this, assuming that one will handles everything everywhere, only to discover that out-of-state property triggers its own separate legal process entirely. Now let's talk about some of the most common mistakes and myths that come up around all of this. The biggest myth is the idea that a will is a complete, all-encompassing document that governs everything you own. It's simply not true, and it's one of the most persistent misunderstandings in estate planning. A will is powerful, but it's really only the backstop. It controls whatever's left over that isn't already directed somewhere else through a beneficiary designation, joint ownership, or a trust. Another common mistake is assuming that updating your will automatically updates everything else. People often rewrite their will after a major life event, like a divorce or the birth of a grandchild, feeling like they've now handled their estate plan, without realizing their retirement accounts, life insurance, and payable-on-death designations are sitting completely untouched with outdated information. A third mistake is adding a child's name to a bank account or property title as a shortcut for convenience or to avoid probate, without understanding that this can unintentionally disinherit other children or create tax complications the parent never intended. So what should you actually do with this information? Start by making a simple, honest list of every account and policy you own, every retirement account, every life insurance policy, every bank account, every piece of real estate. Next to each one, write down whether it has a named beneficiary, whether it's jointly titled, or whether it's held in a trust. Then contact each institution directly, whether that's your 401k provider, your life insurance company, or your bank, and confirm who is currently listed as the beneficiary on file. Don't rely on memory, because outdated forms are exactly how families end up blindsided. If you've set up a living trust, take the time to verify that your major assets have actually been formally retitled into the trust's name, not just mentioned in the trust document. If you own a business, locate your partnership or operating agreement and read the section on what happens if a partner dies. And if you own property in another state, ask a licensed attorney whether a transfer on death deed or a trust might help your family avoid a second, separate probate process later on. None of this needs to happen all in one sitting, but it does need to happen, and sooner is always better than later. At the end of the day, this comes down to something much bigger than paperwork. It's about making sure the people you love are actually taken care of the way you intended, without confusion, without unnecessary legal battles, and without a decades-old form quietly overriding your true wishes. Estate planning isn't really about death. It's about protecting your family from unnecessary hardship during one of the hardest moments they'll ever face. A will is an essential piece of that protection, but it was never meant to stand alone, and now you know exactly why. If this video helped clarify something you'd been wondering about, do a little homework this week. Pull up your retirement account, your life insurance policy, and any jointly held accounts, and just double-check who's listed. It's a small task that can save your family from a genuinely painful outcome. And if you'd like more videos like this one, breaking down estate planning topics in plain, straightforward language, go ahead and subscribe so you don't miss what's coming next. One last reminder before we close. Everything in this video is general education, not legal advice. Estate laws vary from state to state, and the specific rules around beneficiary designations, jointly held property, and trust funding can differ significantly depending on where you live and how your accounts are structured. Before you make any changes or decisions based on what you've heard today, please talk to a licensed estate planning attorney in your state who can look at your specific situation and guide you properly. Thanks so much for watching, and we'll see you in the next one.